Research shows that a relationship breakup is one of the most stressful events in anyone's life. I'm joined now by family law solicitor Brendan Dillon of Dillon Solicitors in Rathfarnham to discuss some of the key issues of family law. You're very welcome, Brendan.
Thank you, Sybil.
Now, when you're meeting a family law client for the first time, what are the key issues to discuss?
Well, Sybil, it's very important for us as practitioners to understand that clients in this situation are obviously in a very stressed situation. This is uncharted territory for them. They very often have immediate concerns that you can address, and what I try to do is understand their concerns, get a background to the circumstances of the breakup, and to give them initial advice and try and allay particular concerns they may have, particularly in relation to their children and also in relation to finances. So I suppose it's trying to look at short-term initial issues and then help them put in place a plan which over a period of time will hopefully allow them to go through the separation process with as much dignity, and also trying to preserve the relationship with their spouse for the best interests of their children.
Now, you mentioned children. How are their interests safeguarded in family law cases?
Well, obviously in the vast majority of family law cases, both parents love their children, but unfortunately in a different way, and reaching agreement in relation to how they parent those children can sometimes be very challenging. The courts have always put children first, but the 2015 Children and Family Law Relationships Act has put children very much in the centre of family law issues, and any decisions and arrangements that are made in relation to children must be, in the eyes of the court, in the best interest of the children. And what the legislation has also done is establish this new concept of the voice of the children, so that the children need to be heard, whether it be either directly by a judge speaking to them, if they're, I suppose, old enough and mature enough to do that, or by an experienced child assessor, psychologist, therapist, speaking to them and providing a report for the assistance of the court.
Okay, let's move on now to collaborative law. What exactly is that?
Well, I mentioned the word non-adversarial, and I suppose when people talk about family law, it is unfortunately something that can end up with conflict. Collaborative law is the complete opposite. Both parties have their own solicitor, but the couple and the solicitors effectively sign what's called a participation agreement, which in effect says they will use everything to try and bring about a outcome which is in the best interest of the children, which is fair, which is equitable, and which does not involve going to court other than to maybe rule and get an order in relation to what they have agreed. It is very successful when it is used, and more importantly gives the parents and the couple the opportunity to make an agreement themselves.
Moving on now, what is the difference between guardianship and custody?
Yes, these are concepts that very often get mixed up. So effectively, guardianship is the rights and obligations of parents in relation to kind of big ticket items such as religious upbringing, health, issues in relation to children, and education. Whereas custody is really the day-to-day duties and parenting of the children. So it's really coming up with parenting plans that effectively ensure that the children are looked after on a weekly basis.
Now, if you want to be separated, do you have to go to court for something like that?
Not necessarily. Most cases end up in court, even where they are agreed, but it is possible to get what's called a separation agreement, which is effectively a contract between the couple to determine or record exactly what they have agreed, whether it be in relation to property, in relation to maintenance, in relation to arrangement, in relation to children. The reason, even though a couple might enter into an amicable agreement, they might go to court, is because they will want to get issues in relation to pensions ruled in a binding manner, and you have to go to court in order to do that.
Okay, moving on to divorce. What are the main factors that the courts must take into account?
Yes, and I suppose the divorce is with us now since 1996, and the Act talks about what's called proper provision, and really what that is about, bringing about a just and equitable, I suppose, finalisation of the couple's assets and their arrangements, and it's allowing both parties to move on and to live independently of the other in as much as they can. I suppose it's very much looking forward, as in making provision for the future, rather than looking back as to who's done what and who contributed what, and that's the I suppose, the essential criteria that the courts look at.
Finally, I suppose this is the area that you specialise in
Yes.
Dillon Solicitors.
Yes, Sybil. And I suppose the thing about family law is that it can obviously be very difficult for people, but I suppose it is trying to put in place a plan, look forward maybe 12 or 15 months and say, well, look, you know, it's almost the start of another phase in their life, and it is also trying to help them reach agreements which protect their children and establish a level of, I suppose, dignity, and maintain a level of dignity between the parents that will continue into the future.
Well, Brendan Dillon, many thanks for that advice.
Thank you.